So I want to introduce Priscilla Selden. I'm sorry, Steve.
Steve Crossland.
Steve Crossland, and he has worked really hard to make this legal license happen, but I will leave it to them because they can describe it and discuss it much better than I can.
Have I met some of you before in the other classes where I've done the presentation? I'm not sure if I see familiar faces. So I was a paralegal for 25 years and then pursued this license we're going to talk to you about. And was, I guess, the second person to get the license in the whole wide world, because Washington's the only state that has it, and I was the second person in Washington. And Steve is the creator of this, going back maybe 20 years vision. Steve's an attorney. He's the chair of the Legal Technician Board with the Washington State Bar Association, and I'm sure other relevant roles that he has, but those are the two main ones. So we're just going to kind of use this PowerPoint as our framework. Please interrupt with questions. Raise your hand so we know you have a question. So he's going to go more from like the program and the rule standpoint. I may jump in, but I'm going to be able to answer your questions about what it's actually like to be a practitioner in this brand new field. Okay.
Thanks, Priscilla. Can you hear me in the background? Good. I would underscore what Priscilla said in terms of asking questions as we move along. I'd kind of like this to be a conversation among us, so that if you have questions, just raise your hand. It's relevant to you at that time, and so let's deal with it at that time. Let me add a little bit to what Priscilla said about my background. Actually, I was born in Yakima, and I lived most of my life just over the hill in Chelan County in Kashmir. I'm a small town sole practitioner. I've been there practicing law for over 40 years. Went to undergraduate school at Stanford and went to law school at Lewis and Clark in Portland. I'm a former president of the Washington State Bar Association. I was president 5 years ago, and was a member of the Board of Governors. And that'll be relevant in a few minutes when I talk about the relationship of the Bar Association with this rule. So I started, as Priscilla said, thinking and talking and contemplating this rule probably 20 to 25 years ago, because I had a big concern and a big interest and passion in making sure that the consuming public had the opportunity to receive qualified, regulated legal services at a price that they can afford. Many of you may not know, but in Washington State and in the United States in general, we're facing a crisis in terms of the delivery of legal services. We have had two civil legal needs studies commissioned by our own state Supreme Court, one in 2002 and one just completed a couple of years ago, or 2 years, a year ago, 2015. And both of those studies revealed that about 80% of poor and moderate income people in the state of Washington cannot afford legal services. And to me, that is a dramatic and disheartening statistic. So the mission of this program, again, is to provide affordable and qualified, regulated legal services to the consuming public. And I really hope many of you will join forces with Priscilla and become a LLLT. As Priscilla said, we're going to kind of pass this back and forth. She, having gone through the program, knows the nuts and bolts about the program, much better able to talk about how the program actually works on the ground. I'm going to give you the introduction and kind of the philosophical reasons why we adopted this program and some of the challenges that we're facing. As Priscilla mentioned, this is the first of its kind in the country and frankly in the world. So we're sort of a laboratory. We're a little crucible here in the state of Washington. I wouldn't say fogging our way along, but picking our way along in terms of developing this program, introducing this program, and more importantly, having the program accepted by the public, the consuming public, and the rest of the lawyers. Lawyers in general, when this rule was first proposed, as you might imagine, were not amused. They didn't think it was a very good idea. And I think they felt it was going to be competition for them. But as I mentioned to you just a moment ago, there's a huge market of unmet civil legal needs. our Chief Justice, I spoke with her in South Carolina a couple of years ago, and she mentioned that 80% that I talked about of unmet civil legal need is about 1.6 million people every year in the state of Washington can't access this legal system. And frankly, the way our government works, access to the legal system is a crucial part of navigating this wonderful system that we have in our country. And so I feel, as you do, very passionate about the work that you people would do. When we developed the program, well, let me back up a little bit. 12 years ago, we began working on the proposed rule. As I mentioned, we met with a certain amount of opposition, but we were asked by the state Supreme Court to develop this rule. I was a chair of a board that was commissioned with that idea of creating this proposed rule. And again, it was a rule that had no equal in the country. So we really developed it at full clock. We sat down and didn't pick a model from Minnesota or California or New York or England. We sat down and said, what would be the best way to meet this unmet need, and came up with this proposed rule. It took about 6 years after we proposed the rule, developed it, before the Supreme Court actually adopted the rule. The Supreme Court adopted the rule.
Page down, is that right?
Yeah, that's
Okay,
great. That's perfect. Adopted the rule in June of 2012. And I know you can read, and you can read this just as well as I, but I'm going to read it because I'm going to emphasize what the Chief Justice of the State Supreme Court said in the order that adopted this rule. The Chief Justice and the majority of the court said, we have a duty to ensure the public can access affordable, legal, and law-related services, and that they are not left to fall prey to the perils of the unregulated marketplace. Some of the first words I mentioned to you was, we want to make sure that the public can access qualified and regulated and affordable legal services. And that's what this program is about. And that's what the Chief Justice and the Supreme Court were saying in 2012 when they adopted the rule. After the court adopted the rule, they created the board. This is the Limited Licensed Legal Technician. That's a mouthful, as you've heard me condense that to the acronym of LLLT, which is still a bit of a mouthful, but a little easier to say than Limited Licensed Legal Technician. The Chief Justice appointed me to chair that board, and I was delighted to have that opportunity. We have 13 members. 4 of whom are non-lawyers. And they're really vital and important voices and minds on our board. So in January of 2013, we began the process of implementing this rule. Again, sort of like getting on the Oregon Trail before there was an Oregon Trail in Missouri, heading to Oregon, picking our way along the way and making decisions that had not been made before. I have to tell you, and I do this almost every time that I give this talk, I want to compliment and pay kudos to several groups of people, because without their input and their involvement and their perseverance, this rule would not exist and would not continue to prosper in the way that it is. First of all is the state Supreme Court. I mean, they had to have some courage to say, we're going to do something that no other court in this country has done. We're going to adopt this rule. I would second compliment the Washington State Bar Association. I mentioned to you that the lawyers were not amused, but I'll tell you, there are no bigger fans now of this rule than the Board of Governors of the Washington State Bar Association. They are to a person in favor of this rule. I have to compliment and praise the board, who has worked diligently for now 3.5 years to implement this rule and put in untold hundreds and hundreds of hours implementing this rule. And the final, and not least, are the Priscillas of the group, the LLLT candidates, people who have been the pioneers to go through this program and now be the first of this profession in the marketplace. And so I really am very proud of and very complimentary of those 4 groups of people and how we've relied upon them to get to where we are. One of the first big decisions we needed to do, yes, sure.
May I ask what the first group you were giving thanks to in regards to the Washington Bar Association?
The four groups that I just mentioned? Yes, the state Supreme Court. Yeah, for having the vision and the courage to adopt this rule. I mean, they kind of went out on a limb. And especially in the face of, people don't like change. Just don't like change. And so, when this was proposed, there were a lot of naysayers digging their heels in saying, we like the status quo, even though 1.6 million people can't access it. Other questions? Yeah.
Do you know of any other states that are looking at this idea?
Good question. Yeah, let me just fast forward to that because that's part of the message I want to send to you folks is probably over the last 3 years, I and the executive director of the state bar have traveled literally all around the United States and Canada to speak about this rule. There's a great deal of interest being generated. I think we've been to 19 or 20 states and provinces. At the present time, there are, I think, 7 states that are actively considering adopting a rule. None have adopted a rule yet, but the states that are looking at it in earnest are mostly west of the Mississippi, California, Oregon, Utah, Colorado, Minnesota, Florida. Florida and Minnesota have, in fact, drafted rules. I think they kind of took ours off the shelf and whited out Washington and put in name your state. And I'm going next week to New York to speak to their bar association. We went to Illinois and I spoke to them. So there's a growing number of states. I spoke at a conference last spring, almost exactly a year ago at Stanford. The ABA brought, the American Bar Association brought together sort of a think tank, people who are interested in the future of the delivery of legal services. And LLLTs were the buzzword. I mean, these are professors and deans of Harvard Law School and Yale and UCLA and USC and, real luminaries in the world of legal services. And the one common word that was, or phrase that was being bantered about was LLLT. This is something that could be a big change. Other questions? So yeah, it's a movement that is, I think, rapidly gaining traction. The rule is intended to be applied to any number of practice areas. So, people act when they have legal problems. It isn't just in one practice area. It's in any number of practice areas. Family law was the first area that was chosen. I mentioned the civil legal needs study that was done in 2002. That study identified family law as one of the areas of highest unmet need. And so the Supreme Court approved that. We are now in the process of recommending to the court the next practice area. We're doing a certain amount of work that needs to be done on our part to prove to the court that this is indeed an appropriate practice area. I don't know what to call it, but it's sort of like elder law. It has to do with preparing wills and powers of attorney and things along those lines.
I was going to just clarify too, because when I first told my friends and family that I'd gotten this license, was working on it and got the license in family law, we talked as if everybody knows what that means, and they don't. And in fact, they thought I would be able to write wills. So family law is really, to boil it down, it's like divorces, child custody, child support. Those are the main, that's when you're talking about family law, that's what you're talking about. It's domestic violence, but yeah.
And thank you, Priscilla, because having been a lawyer now for 43 years, sometimes I speak in condensed phrases, and I don't mean to do that. So please raise your hand and say, I don't understand what you're saying when you mean, say, elder law. That doesn't make sense. And again, we're trying to give, at least in the 50 minutes that we have or so, to give you a flavor of what this program is and really why we're doing it, why it's relevant. A couple other brief things that I want to leave you with before I turn it over to Priscilla. This is kind of the way we went about, I'm not going to spend a lot of time on this, but we sort of broke the project of implementing this rule into discrete packages. And one of the packages was, family law was the first area. And so it's a limited license. So within this world of all the things that people who do, lawyers that practice family law, we wanted to narrow it down in a way that two things could be accomplished. One, that Priscilla and the other LLTs were really hitting the need of what the consuming public needs in terms of the kinds of things that LLTs could do. And then around the edges, we sort of said, let's just leave some of these things out of the license, out of the authorized scope, because maybe they're not done as much as the meat of what the LLT can do. And maybe there are some other peripheral issues that make it a little more complicated. And we want to make sure that the public is served and protected, not only by LLTs, but lawyers and anybody that's involved in the delivery of legal services. As we've been implementing the rule, our board has adopted what we call the 3 A's. We want this program to be affordable. In other words, part of the problem that we have in our country today in terms of the unmet need is we have a diminishing number of lawyers. My age group are going to be retiring. We're half the lawyers. Half of the lawyers are my age group. So in 10 years, half of the Bar Association won't be there anymore, and we're not replacing them with young lawyers, primarily for one reason: the cost of law school is exorbitant. And so a lot of people are saying, I don't know if I can justify being in debt $100,000, $200,000 when I graduate from law school. So we see the LLT as an affordable alternative to delivering legal services. I'm not saying that people shouldn't go to law school. I would do it all over again 100 times over. But this is a reasonable and affordable alternative to going to law school. We want the program to be accessible. So we want to make sure that people who are interested in becoming LLTs can get the necessary education to become LLTs, and that's why I'm really excited that Central is considering doing this. Most of the schools right now that are teaching the core classes, the first 2 years, and Priscilla will talk more about the education, but the first 2 years are in the Puget Sound area. And those of us who live in Eastern Washington know, that's a 2-hour drive. And if I really want to get an education, I'd like to be able to do it here in Ellenser or Wenatchee or Yakima. So the program needs to be affordable, accessible, and we want it to be academically rigorous. That's the 3rd A, academically rigorous. By that we mean, this is not a box off a cereal box and 50 cents sent in. This is an academically rigorous program. You have 2 years of classes in Paul. Priscilla will tell you about this, but also here taught by law professors. So I digress about the 3 A's, but I think that's an important thing for you to know about the filter that the LLT board has used in implementing the program. We created the classes, so we went to law professors and said, these are the things Priscilla and other LLTs can do. What classes do they need to take to be qualified and well-trained to be able to deliver this kind of service? We developed an examination, and we developed rules. RPC means Rules of Professional Conduct. Priscilla and I are held to the same, and we felt when we developed the rule that was important, again, going back to the beginning of my comments, to serve and protect the public, to make sure that the public is as well protected, whether it doesn't matter who's delivering the service, Priscilla or I, the public can know that they get the good housekeeping seal of approval from both of us in terms of the kind of service that they're getting. I think we're going to talk about the scope, and Priscilla's the one that knows this far, far better than I. So let me turn it over to Priscilla. Before I exit, I'm not going to disappear, and I will maybe pop in with some comments as we go on, but questions from the audience at this point. Chris? Good.
So I'm going to go ahead and stick with this format for now, the role, and then if you want to ask me some questions about my experience of working with the rule, we can do that at the end. So Steve, as Steve mentioned, and as I often have to explain when people call me and want me to help them, as to hire me, engage me, is I can't do everything that a lawyer can do, even within the scope of the practice area that I'm licensed. So far, family law is the only area. So this lines out the main types of actions that we can help with, and then within those there are limitations. And I'll tell you what the main limitations that I run into that people want me to be able to do, and I have to sort of go into more depth and explain a little bit more about scope. So the two things that really pop up are, I cannot negotiate for you. So, I mean, legal technicians are basically helping unrepresented people by providing unbundled services. Sort of a traditional lawyer-client model is, where the client would come in and say, here, I have this problem, and the lawyer kind of takes it from there. It's not the same with a legal technician. Not only am I only providing an unbundled service, which means just sort of a piece of what they need at a time, but I can't go to court for them, and I can't negotiate for them. So they have to, so by negotiate, I mean I can't talk to their maybe soon-to-be ex-wife about anything to do with the case. So they have to be, it's a niche then, right? I mean, it's a certain type of individual who, and I'm going to charge quite a bit less than a lawyer. So it's a certain type of individual with that need, somebody who feels, up to those issues, whether it has to do with the relationship with the soon-to-be ex, or just personally comfortable going to court for themselves.
Could I
Yeah,
supplement that? And you framed it very, very well. Two limitations: appear in court and negotiate. And we, when we were developing the rule, thought that was a restriction, or those were restrictions that we thought would be appropriate. Mentioned to you several times, no other state's done this, and when we proposed the rule, the Supreme Court said, we don't know if we actually got it 100% right. We may come back to you with things as we implement the rule. We may come back to you with some recommendations of changes that we think would help improve, not that we got it wrong, just rather that would help improve the services that Priscilla and other LLTs are providing. And these are two things, frankly, that our board is now reconsidering, and we have had the discussions with the state Supreme Court on this issue. We think, as we see the rule being implemented, Priscilla would be doing an even better job for her clients if she could negotiate on behalf of her client, and if she could, in some fashion, appear in court on behalf of her client to explain to the court why we picked these forms, why the form was filled out in this fashion, and frankly, give moral support to your client who you've been working diligently with them until this final step in the process. So, and the court's frankly been pretty open about that. They've said, whatever we need to do to make this better, let's talk about it. So I don't mean to interrupt, but
and leapfrogging off of that, I think as I went through the training program, learned about the rule, and now I'm implementing it. Really, I think it is the courts, because that's where the rubber hits the road. I mean, you have had and still have people come to court who haven't filled out the forms right, don't have the right forms, are hoping the judge will help them, and that can't happen. So it's hard, for the courts and for the judge, but it's also, you end up with frustrated citizens. And there is a sense, I think, and a drive and a desire on the part of the courts to make this process as smooth and as ultimately, I don't know, satisfying is the word, but to have closure for people and not have people, things are getting more complicated all the time. When I got my undergrad degree in this years ago, I've seen things, the complexity has increased so much, even over 25 years. And so, if we can make the process run more smoothly for individuals out there, then everybody's on board with that, is my sense.
One thing you talked about walking over, and maybe we should have asked at the outset, or maybe we should ask both at the outset and see if we dissuaded you or encouraged you. But any of you interested in law school or a LLT or paralegal kind of plot, perfect. That's great. Good. Then this is relevant. Fantastic. I'm glad that many of you are interested. That's wonderful.
So this is another, it's basically another profession within the legal world, you know. I was a paralegal for 25 years, and that had one set of parameters. I thought about law school, but I didn't feel like I could commit. And so this is sort of a third way within the legal profession, which I'm finding very satisfying. So I'm going to go on from this. Oh, I just want to mention two other things. Occasionally, I'll have a client or somebody who wants to engage me who owns a home. For example, that's another area. What I have to do in those cases, and I can do this with the negotiation piece or the appearing in court piece, I have to kind of collaborate with a lawyer. And in my first client, I had to do that. So she had a certain fee she paid me to do the sort of basic paperwork. But for this other piece that the board and the court and the rule has deemed more complex and beyond our scope, she just had to, you know, we kind of tag team. So she hired an attorney for that piece. And so he also then was providing her with an unbundled service. It's a new way, but it seems to be very practical and relevant for people's lives nowadays. More affordable as well. This is a list of the things that we can do. I don't know if you have the context for it to seem terribly interesting or relevant, but it's some basic tasks that people seem to really need help with. I mentioned the complexity. There's actually a lot of good information out there for people. There are groups around the state, the legal aid providers have worked very diligently at making a website that's very robust and full of all these forms, and people still have trouble finding them. They have trouble finding them, understanding them. I mean, I use those a lot, and it's complicated for me. So I mean, it takes a lot of time. It's nice. It's great to know that there is that, you know, there is that collaboration across the board, and we're all kind of joining together to try to help people be more successful and less stressed in this case. Now we're getting into some of those restrictions of representing the client in court, negotiating their rights. The third one, communicate with another person regarding the client's position, is sort of a subset of negotiation, I guess. So I'm really clear up front with people. I don't want to overpromise. We actually have a form we have to give them when they come on, when they engage us, that lines this out for them. You wouldn't want to get in a situation where there was a misunderstanding, you know, partway through. So here are the basic requirements. When I went for my license, I had a BA, a 4-year degree, which I didn't need. But I also had an AA from Edmonds Community College, which has a Bar Association approved program. And that's all sort of stuff you have to get out of the way first, the associate level degree. There is also a requirement before you can earn your license, 3,000 hours of work, working under the supervision of an attorney. So it's a complex and extensive requirement to meet. This would be a good one for folks who are, you know, seriously considering pursuing this to print out and look at. It is kind of complicated, but I think as the schools around the state come on board with this more, there'll be help helping you reach your way through. Being in the first class, it was a lot to try to consider, but there's that 3,000 hours.
And I would add, in supplement to what Priscilla just said, we would be happy to speak with any or all of you at any point in time about this program. We're both very passionate about it. You also can go online, the Washington State Bar Association website, it's WSBA, and then LLLT, and it will take you to the section of the WSBA website that's specifically attributable to the LLLT program. And you can speak with our staff person at the Washington State Bar Association, who would be of great assistance in guiding you through the process if you're interested in gaining more knowledge about this.
So because I had a BA, as you all will, when I went to get my specific degree 25 years ago as a paralegal Edmonds Community College. I only had to go for 1 year. I had to take the core courses, civil procedure, legal research. So I was able to use, it's normally a 2-year program, but I was able to, get rid of 1 year because I had my BA. And then after that, then there's this year of classes that you have to take in your practice area that's live streamed right now by the 3 law schools in the state. So it's a complicated path, but
As we were developing his classes at the law school level, I mentioned that we brought professors from all 3 law schools in the state together and said, what do these classes look like? And how are we going to teach them? The law school said, we'll teach them. We're happy to do that. And one of the law school professors said something that I think was profound then, and I think it's going to be even more profound as people like Priscilla get into the marketplace. In his comment, he'd been at the UW Law School for about 30 years. He said, I think LLTs will be better qualified to deliver legal services in the area of family law than a recently graduated law student. And the reason is, Priscilla had far more family law classes in the LLT program than I did going through law school. I maybe had 1. You had 3/4, 15 credits. So, I really think in many ways LLTs are specialists in the area of family law, whereas we coming out of law schools are more generalists. We're trained in a lot of different things, but Priscilla is very well trained in the area of family.
yeah, and it's interesting because somebody can come off the street and hire Steve in the area of family law, and even though Steve, doesn't have a lot of experience in it, and he can do everything for them. For me, when somebody wants to engage me, I have to do this whole screening process first, like, well, what do you need? Here's what I can do. So it's interesting, and someday you'll get a chance to kind of compare how those 2 worlds survive.
Priscilla, can you distinguish the 3 different exams?
Right, yes I can, where it says examinations. So the core education exam was the National Federation of Paralegal Associations and the National Legal, there are 2 sort of national paralegal associations. They both have exams that are completely voluntary. I never took those exams. I never thought I needed to. I was just hogwash. Well, then it ended up being a preliminary for this license. So I had to hurry up and do that, a couple years ago before I got into the classes. The practice area exam is one of the 2. There's a sort of almost a mini bar exam at the very end before you can get your license. I was taking it about a year ago right now. And it's just a substantive exam that asks you all about the family law subject matter. And as a companion with that is an exam on the ethics. There's a whole quarter of ethics in the program through the University of Washington Law School and for the law schools. And so, I guess similar to bar exams. I don't know.
Yeah, very
Multiple
similar.
choice essay, short answer.
So I have another question. So after the education part, when you have, the paralegal part, and you have to take the practice area at the law school, do you have to go through an admissions process? How do you get into the law school?
You don't, that, which is kind of cool. You don't have to get admitted to take those classes. If you've met the criteria, then you're in, right, Steve?
That's
you don't
right,
have to be accepted like you do in a law school.
We've thought about requiring the first exam to be taken in the core area. We've thought about maybe requiring that exam be taken before you begin the practice area classes, just so that you've mastered that core class level of education. One of the other really interesting things about the practice area classes, and it was particularly relevant for Priscilla and me, both of us speak from this part of the state. I mentioned the 3 A's, affordable and accessible. The classes, and Priscilla can talk to this better than I, but the classes for the practice area are taught live online. So they're streamed from the UW professors, usually sometimes a professor and an adjunct professor will co-teach the class. And so you can be sitting here in Ellensburg on a computer, connected live with your other classmates and the professors. And so again, part of our thinking was, we want to make sure that if there's people in Ellensburg or Kashmir or India or Spokane or Pomeroy, if they're interested in becoming triple LPs, they don't have to go to Spokane or Seattle to get these practice area classes. So I think that's one of the really wonderful and innovative parts of this program.
Agreed, yep.
Yeah.
So when it says 3,000 hours of the substantive, whatever stuff, so that's being a paralegal, could it be like something like in correction or something like that? Or?
It has to be under the supervision of a licensed lawyer in the state of Washington. It doesn't have to be practice area specific. So you could come to Kashmir, Priscilla could have, if she didn't already have had 25 years of practice. The idea was we wanted to make sure that people who become triple LPs understand the dynamics of working in an attorney-client relationship, if they want to go out on their own and run a business on their own, how you do that as an entrepreneur and a business person. So we wanted them to have some kind of real life exposure with training wheels on, so to speak, in a law office. And I have to tell you, and I'm embarrassed to tell you this, the first law office I put my foot in was my own. And that was kind of scary. I mean, I should not have been opening my own office in November of 1973 without ever having walked in a law office. I mean, that's insane. Whereas Priscilla has had the great good fortune of having had really a lifetime of experience. And so
But so to answer your question directly, no, being a corrections officer in itself wouldn't do it. But part of my 3,000 hours, because it had to be within a certain time frame, was volunteer also. So you can volunteer as long as you're working under the supervision of an attorney.
but you have a senior.
Non-paid stuff and all that.
That volunteer wouldn't be paid, but yeah, and it has to be substantive law experience. So it's not being the receptionist. It's basically doing paralegal work. I mean, really, the people who are pursuing this license are paralegals. It's great. And like I said, having been a paralegal for 25 years, I was pretty much maxed out, and wanted so that everything kind of came together where this was a great career path for me.
But you can get those 3,000 hours in a 6-year period of time, so you don't have to just drop everything and spend a year and a half, 18 months working to gain this 3,000 hours.
These are the courses that, so if for example, Central we're going to have this program, and these are the courses they would need to offer to meet the criteria of the program, the core education piece. Any questions on that? Does some of those look familiar to you? Have you taken some classes like that here? I imagine you have, yeah. Let's see what's next. And then this is that last piece. This is the piece where once you're all in, you've got you're maybe working as a paralegal in a firm, you've got your AA degree, or you can see I don't think it says here that you have to have the AA degree from an ABA approved program. Yeah, that may still be getting subject to tweaks. But in any case, this is that part where you decide this is really what I want to do, and you take that last 3/4 of classes that are live streamed. It was like 2 nights a week for 3/4, and then that sets you up for the exam, the big exams.
Questions? We're hopefully not dissuading you from doing this.
Here's that ethics piece, and it was really fun for me because I never knew anything about what the ethics rules said. It was an area that the lawyers they'd be the ones that would decide whether they could take a case if there was a conflict of interest with a current client or a previous client, or make us as a paralegal, the attorneys make the decisions. We're going to take this case. This is where we need to go with it. Now I'm doing that, and it's you can imagine it's challenging, fun. It keeps it interesting.
And I have to say, when we go around the country and we talk to other Supreme Courts and bar associations about this program, a couple of things are misunderstood about the program. One of them is the rigor of the academic process, how really serious we have made the education component of this. I think sometimes people just say, oh, you know, you can take a couple classes and, again, as I said before, send in a box stop at 50 cents and you get a license. When people see what Priscilla has gone through, they sit up and take notice. The other thing that I think is eye-opening and gives the program a great deal of credibility with skeptics around the country is just what we've been talking about. I think when other critics say or learn that Priscilla is held to the same standard of care, has the same rules of professional conduct, has the same ethical responsibilities that I do, because we both want to protect the public. We want the public to know that we have taken our delivery of service to them very seriously. That's pretty sobering when we go around the country and people say, oh, that's a simple little program, it's just glorified some kind of program.
And I think one reason for that sort of preconceived notion is, you know, you've probably all noticed in the Little Nickel or in Craigslist, people who offer, you know, I can do your divorce for $150 or your bankruptcy for $300. And that's out there, and that's part of what this rule was supposed to, was designed to address, is there is this whole unregulated sort of world out there of people who, you know, they say, oh, I just fill out your forms. And some, you know, in Arizona, they do have something called document preparers, and they have to be licensed. The key difference with the legal technician is I can give legal advice. That's like the key difference. So I can strategize. Legal advice means I'm not just educating you what the law is on divorce or child custody or wills for that matter. You're coming to me with your problem, and I'm helping you solve your specific problem. So that is, up till now, lawyers have been the only ones in the state and the country who could do that.
The other thing it changes is the rule of ethics in the state of Washington. Nowhere in the country can a person own their own business, hang their shingle alone. Before, you had to be an attorney who could hang their shingle, and a lawyer and a paralegal could never work together in the same office and be, you know, this changes the ethics rules. And my own other question, because I'm trying to be specific for them, is, and we got 5 minutes, is that how do you go to the law school and tell them that you're on this path? Would you go onto the website and see the core classes? Like, how do you do that? How would I tell a student?
How do you get into the practice?
Yeah, how do you, yeah.
Good, very, very good question. And again, I would say go to the WSBA website, LLLT, and speak with Ellen Reed, who is our staff person there. She's wonderful about, even at this stage, even while you're just thinking about perhaps that as a career path, she would be very helpful to get you to understand, you know, what you need to do. And she would, if you, let's say you're at the point of taking the practice area classes, you're already taking the core classes here at Central, for example, then you'd be on the phone or online with Ellen, and she'd say, here's the application for the classes at dubbed, and this is how you apply. And
Thank you.
And you're right, that's what you just said is one of the most important things about LLLTs is you can practice on your own. You can go out anywhere in the state of Washington, hang out your shingle, and become independent and deliver your services without the supervision and guidance of a lawyer, which is huge, it's revolutionary.
Yeah. So are there any, well, this tells you about, you know, the future, what they're working on this year, scaling up to meet demand. Looks like community colleges are going to adjust their curriculum to.
Yes, and along those lines, I mentioned most of the classes for the core classes, the paralegal classes, have been within the Puget Sound area, mostly in the Seattle-Tacoma area. We are in the process of having the Supreme Court change the rules so that those classes can be taught most anywhere in the state of Washington. We've been working closely with the State Board of Community and Technical Colleges. There are probably 3 other colleges that are ready to begin teaching core classes. None of them in Eastern Washington, by the way. And we are going to be speaking to another college that I had not even heard was interested, probably in the next 2 weeks, who are like you, interested in being qualified to deliver the core classes. So I can't tell you enough. This is, I believe, a groundswell of support for this kind of education, and it has occurred now. We only have a couple minutes.
Yeah, any last questions, practical questions, or somebody raise their hand? No?
We can
Yeah.
hang
Is
out.
there a particular code of ethics that paralegals abide by?
Paralegals actually do, and again, nothing regarding paralegals is really required by law. So, but there is a model code of ethics. National Federation of Paralegal Associations has a model code of ethics. I doubt that it overlaps much with these RPCs. There may be some, but the rules of professional conduct now that legal technicians have are almost identical to what lawyers have because of the parallels there. So, yeah, I did study that in order to take one of the exams, one of the early exams. That's a good thing to know about.
Thank you so much for
You're
your time.
welcome. Thank you. for
Thank you.
inviting us.